Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is March 8th, 2018. This is our bi-weekly community conference call. We try to answer your questions as you have posted. As usual, I will go over what I consider to be frequently asked questions first, invite from you any follow-up questions on whatever I'm discussing. At the end of it, then we'll start with other questions that are not frequently asked. I don't think I'm going to have time for new questions. I have to be out of here at exactly 1:30. So let's begin with that which has been posted and is marked as frequently asked questions. This question has come up quite a lot, actually. Many times it happens, let's say you are a technical person and you get an MBA into Wharton or one of the prestigious schools. So the question is, can I go back to F1 from H1 even while my green card is going on? So the first thing is, remember, on any of these forms, including the forms for student visa, student status, or even the visa, the question that is asked is, have you or has anybody on your behalf filed an immigrant visa? Immigrant visa is form I-140. PERM is not immigrant visa. So once again, if the I-140 has not been filed, then the answer to the question, has anybody applied for your immigrant visa or have you applied for immigrant visa? The answer is no. In this respect, another question that comes up is, what if your wife or your husband's name is listed as a derivative while you are the main applicant? Does your husband or does your wife have to also state that the immigrant visa has been filed? I reviewed this issue a few months ago, and I believe that in such a situation, the spouse should state that an immigrant visa has been applied. Now, so the question that I'm being asked by Chinmaya is that, can I go to this dream university? Is that going to be okay? And the answer is, yeah, obviously you can try. And Chinmaya knows that I have answered this question in the past regarding an I-140, and he knows that his chances of getting PERM are slightly better. I think what happens is, Chinmaya, when you are going to a good school, chances are government will accommodate and they will allow you to go back on F1 because it is definitely a promotion path, a career progression for you. I can't predict whether the government will be reasonable or not, but reasonableness would require that they allow you to convert to F1. A few years ago, we actually had a series of about 25 people who went on to F1 even when their 485s were pending. That was almost unprecedented. They went on to F1 through visa stamping even while their 485s were pending. We had a fairly large number of students on the phone that day, 100 plus, who were all thinking of going back to school. And out of those, at least 25 sent me emails back saying that their visas had been successfully processed. So under the Trump administration, I do not know how things are going to work out, but as long as predicting your chances, or as far as predicting your chances is concerned, I think you certainly have a shot. Okay. *5 if you have any follow-up questions on this. Press *5 on your telephone. Okay. Let's go on to the next frequently asked question. So everybody's concerned about the H-40AD termination and converted back to H1. As you know, government said they will publish the regulations rescinding the H-40AD somewhere in June. Remember, they have to give a good reason why they want to rescind, and the reason that they hate people who are here and who are not white is not a good enough reason. So they've got to come up with some kind of a justification for revocation of the regulations. if it were not that complicated, they would have done it in February as they had told the court that they would. So once the regulations are published, you will get at least 30 days, maybe 60 days to put in comments. I would advise people to put in all your comments. The more comments, the better it is. The government has to address, at least go through the comments and address all the key areas of concern that is required by law before they issue final regulations. Will they give us any grace period? I do not know. Will they get sued? It depends. It depends upon what the grounds for the revocation are and how well they do procedurally as well as substantively. They have to follow both the procedures as well as the basic law that applies to this area. So the question here from Truptic82 is, I was on H1 before completed all 6 years and converted to H4. So if they end, my EAD expires in November 2018, which leaves me no option of applying for renewal. Can I file another H1? Well, if you have already completed 6 years, you cannot go back to H1 unless you leave the United States for at least 1 year or unless you start a green card. Then you would be able to apply for an H1 extension based upon either the first year anniversary of the filing or I-140 approval, whichever comes first. If in the next couple of months my spouse decides to switch jobs, will I be able to extend my EAD at that time, or do I have to wait to fall under the 180 days? Yeah, you have to fall under 180 days. Mere change in job doesn't allow you to reset the period for yourself. *5 if you have a follow-up question on this. Press *5 on your phone if you have a follow-up question. Okay. Let's go on to the next question, next frequently asked question. If an H-1B transfer is denied, can I go back to my old employer? And the government has said, actually the regulations say the same thing. Frankly, these regulations are confusing. Why are they confusing? Under the regulations, if you are working for employer X and you leave them based upon a transfer filing by employer Y, and now you are working for employer Y, approval is not in hand, but they have filed the H1 transfer, so you can start working for them. Under the law, employer X should be revoking your H1. However, the new regulations starting January 17th say this. They say that if your transfer is denied, you can actually go back and start working for the old employer, which means the regulations presuppose that the old employer would not revoke the H1. That is a strange result when the government has been saying for the last many years that in order for the employer to protect themselves, they must revoke the H1 when the employee leaves. But that is the law, so you can go back to the old employer. Another question is, when does AC-21 job portability begin, the 180-day calculation? Okay, let's do it this way. It's a little complicated, but not so much. So the idea is your 485 must have been pending 180 days and your I-140 must have been approved. Only then you can qualify. There's a little variation in the regulations of 17 January that say it should be I-140 should be approvable when filed. But let's leave that aside for a moment. So I-485 is pending 180 days and I-140 is approved. Does the pendency of the 485 begin after the I-140 approval? No. So let's take an example. Let's say you filed I-140 and 485 together because your dates were current. 100 days later, you filed I-140, you filed 485. 100 days later, I-140 gets approved. Now the question is, do I have to wait 180 days or just 80 days? And the answer is just 80 days, because after 80 days, 485 would have been pending 180 days. I hope that makes sense. Can an H-1 be extended through a new employer while I-140 is in process? The answer is yes. It can be, because there are two bases for an H-1 extension beyond 6 years. One is that your perm has been pending for 1 year, or filed and pending, or green card process is pending for 1 year. And the other is that your I-140 is approved. So if you meet the first requirement, which is 1 year anniversary of your green card, then you can use that as the basis to extend an H-1 for 1 year through any employer. Let's look at the questions from Tahir. While I'm moving with my H-1 new employer B, if something goes wrong, can I go back? And the answer is yes. I just discussed that. Does AC-21 portability apply to me? I-485 is not yet filed. The answer is no. Your 485 must have been filed and pending 180 days. While my green card is in process with the new employer and I'm waiting for I-140 approval with new employer. Okay, that's a little confusing. What will happen if my time to extend H-1 petition comes up? Can I still extend my H-1 with new employer even if I-140 with new employer is in process and not yet approved? Can I use my old employer's approved I-140? Yes, you can. Yes, you can. So, as I said, for the first half of your question, or first 2/3 of your question, you can apply for an extension based upon two reasons. Either the first year anniversary of your green card filing, that your perm was filed a year ago, or based upon I-140 approval. So for the first 2/3 of your question, the answer is yes, you can file for 1 year extension if perm was started a year ago. The second third of the question, the last part of the question says, can I get an extension based upon the old employer's I-140 approval? The answer is yes, as long as one of the two things exist. Either the I-140 has not been revoked, in that case you can use it for extensions, or the I-140 was revoked by the old employer but after 180 days of approval. In both cases, you can extend your H-1 through some other employer like employer B, even while employer B's own I-140 is still in process. *5 if you have a follow-up question on this, folks. Press *5 on your phone. Okay, I have two questions on this. Let's see. Okay, now 3 questions from Nebraska, Minnesota, and Illinois. So let's start with Nebraska. Nebraska, go ahead, please.
Hello, sir. This is Tahir here.
Ji Tahir.
I have one question. Like, if I have my stamping done in January 2000 in this year, 2018, and it is valid until 2020. Okay. With my existing employer. So if I change my employer and then go to India, do I need to go for stamping again, or the stamping will valid?
Well, I've had this discussion with the consulate that if I already have a valid visa stamp and I change employers, do I still have to go back for new stamping? The consulate said yes, and I said, look at your standard operating procedures. The Foreign Affairs Manual says I don't have to. So my judgment is you don't have to. You can travel with that stamp. Okay.
Okay, sir. All right.
Good luck, sir.
Thank you.
You're welcome. Okay, let's go to Minnesota. Minnesota, go ahead, please.
Hello, Rajuji. My question is regarding the previous question follow-up. Actually, if someone changes status from H4 to H1, fearing about this EAD, and for good, they did not revoke the EAD. If after 1 year, can they come back to H4 and not apply for new EAD?
No.
Since they have
No.
a valid.
Once you convert status from H4 to H1, as far as I can tell, both the H4 and the EAD is gone. So if you want to, if the EAD still is around and you want to convert back to EAD, you would have to file H4 and EAD again.
Okay.
All right. Good luck, sir.
Okay, sir. Thank you so much.
You're welcome. Okay. And the last question in this context was from Illinois. Illinois, go ahead, please.
Hi, sir. Good morning. So my question is, again, a follow-up question on the same thing which you just talked about. You might have even just answered it, but I just want to make sure I understand this right. So I'm in a similar situation, same employer for 11 years.
Okay.
The question I have is, if I change employers now, and if I get a short-term extension with the new employer, and in the meantime, if the previous employer withdraws or revokes the 140, will the new employer be able to file a multiple H1 extension with that withdrawn or revoked I-140 from the previous employer?
The answer is, if the 140 was approved and stayed approved for 180 days, then even if the old employer revokes the I-140, you get to keep getting extensions.
Okay, sir. Even the new employer can continue getting the extension if the 140 has been approved for more than 180 days. Okay.
That is correct. Approved for 180 days.
Okay, sir. Thank you.
After that, even if revoked, we don't care.
Okay. So you can go for multiple extensions.
Yes, sir. You can.
Okay, thank you.
You're welcome. Okay, so let's get back on track to... This is another one, and I think I deleted a question here by mistake. I will try to answer that one. That one was from Zoomer123. Sorry, I deleted your question by mistake, but I kind of remember what you asked me. I couldn't answer the question exactly anyway. So, the question is, which jobs can qualify for an H-1B visa? If you had asked me this question 3 months ago, I would have given you a slightly different answer. Under Trump, I suspect if lawyers do not prepare for cases very, very carefully, making sure all expectations of the government are taken care of, we're going to have a very high rate of denials. The good news is that we are still winning cases, even very difficult cases. We just got an approval on a very difficult RFE on the job of a programmer analyst, which government has been saying we are going to deny. But we were able to show to the government that this was a professional job. Similarly, we had one for data scientists. They were creating all kinds of issues, but we were able to win that case. Both these approvals came last week. I'll try to find some time and give a write-up on that so you can see. But what kind of jobs qualify is as follows. First of all, that job that is under consideration must require at least the US equivalent of a bachelor's degree, and the bachelor's degree must be in a specific subject. Right now, they are denying cases, for example, of systems analysts, saying that, yeah, even though normally a degree is required, a degree in many different fields could do. That is completely ignoring the fact that systems analyst can be somebody who has a degree in computer-related fields and experience in the field in which they are doing the system analysis. Or they can have a degree in the field and background and understanding of computers. So let me give you an example. If I were to prepare software for the legal industry, for a law firm, I would either look for a lawyer who knows about computers to do systems analysis, or I would look for a computer professional who knows about the legal profession. And both of these things are accurate. But if you go by the government standard, they'll say, no, degree is not required in a specific subject. I intend to win these cases, whether I have to go to court over it. We are preparing all our cases, every single one of them. I am spending time on each case up front because we are quite sure that government is going to create certain issues. We have prepared for them, and all our cases will be prepared with the court in mind, that we might end up going to court over them, and we are going to be ready for that. Because no matter how much discretion the government has, they still have to abide the law. So H-1B is available for those jobs that require a specific degree, or and the person who is applying for the H-1B must have that degree or a combination of experience plus degree. So let's say bachelor's in commerce with 3 years of technology experience would probably give you a degree in a bachelor's in information systems. That's one example. That is still available. That is the law. They can't take that away. We just have to be a lot more thorough with our document preparation, but the law is the same. So that should tell you what their expectations are. Now the question is, who decides what degree is required? So they look at either the standard government sources to see if these kind of jobs require a degree, or industrial, you have to produce data from the industry. And this is all this is relevant for Zoomer, because he had asked me a question, I think, about electronics or electrical engineering. So industry data, or you have to prove that the job is so complex that it requires at least a bachelor's degree. To give you an example, let's say the applicant that we are working for has a job that requires, I don't know, creating distributed databases, and the data level is petabytes of data. They are making parameterized queries. They are doing triggers and stored procedures, and they are working with high-end databases or data marts or data warehouses. Typically, this looks like a high-end job, and the project worth is millions of dollars. This is a high-end job. So the job itself speaks for itself that it requires a professional. That's another example. So these are some of the things that they are looking for. Now the question is from Swecha Bhattarai. Swecha says, I'm an international student working for somebody. I have an MA in Global Development and Peace. International Political Economy and Development is my specialization. So I'm a Registration and Outreach Associate. And I organize and run Youth Assembly Conference. I manage the administrative work. Now, see, here I can't, looking at your job, I can't say that your job requires the degree that you have. So, for instance, if you were a research assistant who basically worked on international political economy and development issues, that would be an H-1B job. So it should be clear from the job that you can't do this job without this kind of a degree. I hope that kind of explains these issues to you. *5 if you have a follow-up question on this. *5. Press *5 on your phone if you have a follow-up question. Okay. Let's go to the next frequently asked question. So this one is also a very frequently asked question. Who can do an EB-1C case? This is International Managers or Executives Green Card. So there are two kinds of managers or executives. Somebody manages a function, an essential and critical function of the corporation. Even though they don't manage any staff, they would be considered a manager. One example is, I've given this example before, we had a case, this is a real case, where a gentleman was only called in to price contracts over $10 million. The company is a 30,000 employee company. They got their L1A denial. We looked at the case. It was quite obvious that this was a case of a high-level manager. Their salary and their reporting was the same as other VPs. Even though he was not managing any staff, he had a lot of discretion in creating the pricing structure for large projects. So that's an example of a functional manager. No corporation can survive without a good pricing structure. It's a critical function of an organization in the services business. So obviously he was doing it, he was managing it. So he was a functional manager. Then there's another kind of manager, which is a people manager. So if you are managing a team of 25 software engineers, they have to be professional employees. It can't be 25 dock workers. Then you're a supervisor, you're not a manager. For a manager, the staff must be professional, high-end staff. And can you count people that you manage overseas? The government has said relatively recently, about a year ago, that yes, you can count those people as well. And what if the number of people you manage has changed over a period of time? I think that's okay. So I hope that answers your questions. *5 if you have a follow-up question on this. Press *5 on your phone. Okay. Let's go on to the next frequently asked question. Ladies and gentlemen, I will not be able to do new questions today. I have to be out at exactly 1:30. Going back to the frequently asked questions, I thought we just discussed this 180-day rule for priority dates H-1B extension. Let's see. I have a quick question about the mystery behind 180 days staying with the employer with whom my I-140 is approved. So if I-140 is approved with date December 2014, notice is November 2017, do I have to wait 180 days, 6 months from the notice date? No. I've done this a few times, I'll do it one more time. The way this works is, beginning 17 January, and it goes back in time. If your I-140 is approved, immediately, I don't recall how far back in time it goes about the priority date rule, but let's say this, beginning January 17 forward, there's some of it that goes backward too. As soon as your I-140 is approved, the priority date is yours, even if the employer revokes the I-140 the second day or the same day. So the priority date becomes yours the moment the I-140 is approved. If the I-140 gets approved and stays approved for 180 days, and the employer then sends a letter to revoke the I-140 on the 181st day, not only do you keep your priority date, you also maintain the right to keep extending your H1 and I believe your wife's H4EAD as well, even if the old employer revokes your I-140. So you see the point? The 180 days is the time for which the I-140 should stay unrevoked. Okay. So I hope that helps. Now, an interesting question is, what if I want to leave before the 180 days? And the answer is we don't really care as long as the case stays, I-140 stays unrevoked for 180 days, whether you left the first day or the 10th day or 179th day, we don't really care. So it's not a requirement of the law that not only must the I-140 be approved, you must continue staying with the employer for 180 days. Also remember, even if you left before the I-140 approval, the same law applies. I-140 got approved, stayed approved for 180 days, but you left even before the I-140 was filed. or approved, as long as it was all done honestly in good faith, you should have no problem. Same law protects you. Star 5 if you have a follow-up question, guys. Star 5. Okay. All right. There is a question from California. I'm actually a little scared of talking to people from California. Trump Attorney General has sued California. Talk about nuts. Okay, so California, go ahead with your question.
Hello, sir. Thank you for making this call. Actually, my number is from California, but I'm in Illinois.
Okay.
So my question is, if 140 is approved from employer A, and I change my employer, I'm right now an employer B, and my 140 is also approved from different employer, current employer. But problem is my previous priority date is not captured in my new 140.
That's okay.
So
that's
how
okay.
I can get to
That's okay. Your priority date does not have to show on the new approval notice. As long as the priority date has been established, you are entitled to it, and the government should give it to you automatically without you having to make any heroic effort.
So I have to request for that, or when my date is current?
They call it data sweeps. They do periodic data sweeps and automatically assign to you the earliest priority date applicable, which is data sweep is just a weird way of saying we run reports on our databases or queries on our databases. And they should be doing it automatically for you. But no harm in asking for it. You can send a letter in. You can even call them up and make sure you're getting the earliest priority date.
Yes, my second question is I did this process, and after like 4 or 5 months, my online status saying they approve my same receipt and new date. So that's mean they capture my previous priority date in my 140.
You have deeper knowledge in this than I do because it's your case. I don't know what they did, but if they have made some changes, I can only guess that those are good for you and they have changed the priority date on your approval.
But now I asked my employer, but they are not sharing me new copy. So I'm confused if this approved or not approved.
I don't think other than filing a Freedom of Information Act might get you that information. So you can try filing a FOIA request. Okay.
And I have to send same address which my 140 filed.
Read the FOIA instructions on the USCIS website. It'll tell you what to do. Okay.
Thank you so much.
You're welcome. Good luck.
Thank you.
Okay. Let's get back on track. So this is another very interesting question that comes up quite a lot. I'm on H-1B. Can I take leave without pay for a couple of months? Does it hurt my status? And the answer is a little complicated. If you look at the Department of Labor regulations, they allow employees for their convenience to take leave for things like tourism. So if you say, I want to take 20 days off and I want to go visit Grand Canyon and Niagara Falls and Yosemite Park or whatever, you could do that without losing your status. But if it is being used by the employer to bench you, both them and you can be in trouble. What if it's a medical leave of absence? As long as you have a medical certificate and necessity, and your leave is coextensive with the existence of that necessity, I think that's okay as well. I mentioned this case quite a lot. I had a case of a friend actually, whose sister was on H-1B and she was very ill, hospitalized in and out of hospitals for a year. Then she got married and we applied for her H-4. Government said she's been out of status, she hasn't worked for a year. We produced evidence of medical necessity. The case was approved. So, couple of months are acceptable if the reasons are honest reasons and not a pretext or an excuse to be off a project and be benched. Star 5 if you have follow-up questions on this. Star 5. Okay, we have a follow-up question from North Carolina. Another one, 2. Okay, let's start with North Carolina. You logged in first. North Carolina, go ahead, please.
Hi, good afternoon. So I'm waiting for my H1 approval amendment. My previous H1 extension got denied, and there was an amendment filed before that. That amendment is yet to come to a decision, but I am almost nearing 240 days in 20 days. So my question is, if I can go on my spouse's H4 and be on LOA until this H1 amendment decision comes in.
Well, I think you have a problem. There is a new regulation under HCFR 214. That regulation was added on 17th January. That regulation says if you have a series of H1s pending, amendment, extension, amendment, and status is dependent one from the other, if any one of them is denied, the subsequent ones fail. So if an extension is denied, the amendment is no good. Therefore, in my view, you would be well advised to look at your options from a slightly different perspective, that you're not going to get status in the United States. Do you want to go get H4 visa stamping, come back, or do you want to wait for the H1 approval? This is too complicated for me to answer without knowing all the facts, knowing all the strengths of your case or the weaknesses. You should be discussing this with your lawyers. But the bottom line is simple. If in a series of H1 filings, the subsequent relies upon the previous and the previous is denied, the subsequent request for change of status or extension is automatically denied. They'll give you the H1. If it is approved, you'll have to go outside for visa stamping. Make sense?
Yeah, but so can I, can I still stay here and meanwhile apply for HOS on
I don't think so. I don't think so. Because let's say you filed an amendment, an extension, and a transfer. Okay, amendment is pending, extension is denied. Okay. Now, if there's time remaining on the original case and the amendment covers that part, maybe, but I wouldn't bet on it. There are too many variables, like I said. I would have to know your case. I think a clean getaway and an H4 stamping is a good idea in cases like this. But by no means should you take my word for it. Either fix up a consultation, show me the paperwork, go over the paperwork with me, or talk to your own lawyers. You have lawyers, talk with them, ask them what they suggest. If what they suggest doesn't make sense, call back in 2 weeks, we can talk about it again.
How can I reach back to you for the consultation?
Just send an email to help@immigration.com. That's my email. That's my direct email. Okay. Just remind me that this is what happened, and I'll try to set up a call as quickly as we can. We are pretty busy these few weeks with the H1 filings. Okay.
Okay. I'll mention the call from North Carolina as reference. Thank you so much.
At all. Good luck, ma'am.
Thank you.
Bye. Let's go to Connecticut. Connecticut, go ahead, please.
Good afternoon, sir. So my question is a follow-up to the leave of absence on H-1B.
Sure.
So if I have a personal condition, then I think your answer addressed that part. But what if my wife has a condition and I would prefer to stay home to support her during some treatment?
Isn't there a Family Medical Leave Act, FMLA? If you are covered by FMLA, which is available not only to cover yourself but also to cover your family, I think FMLA allows you almost 8 weeks of leave or even more. Double check on the FMLA. Okay. That should give you some idea.
Okay.
Okay.
All right. Thank you, sir.
Good luck, sir.
Thank you. Thank you.
Bye-bye. Guys, it takes tremendous courage to take care of somebody who's not well. Just wish you the best of luck. Okay, so let's go back to, I'm not going to have time for any new questions. I've got about 21 minutes to go over other questions that were posted. So let's go. Ravik, for you, I'm on H-1B, working full-time. This is not a contract job. Working in Virginia, want to transfer to Pennsylvania. You'll have to do an H-1B amendment, Ravik. And I can't predict what your case is going to be like. You should talk with your lawyers. Let them assess your case. We are still getting H-1 approvals, but I'm not filing unnecessary H-1s. If I don't have to, I won't. But the thing is, if the case gets denied, you can stay in Virginia and not move to Pennsylvania unless they try to revoke your H-1, which is unlikely. It could happen. So if you don't want to poke a bear, just let it be. But at least get your case assessed. Let your lawyers take a look at it. Maybe you have a very good case. It's a case easy to win. Okay. Star 5 if you have a follow-up question. Star 5. You don't? Okay. Devi 9285. I applied H-1B April 2017 through a company. Not employed with that company. Start date mentioned was October 2017. Employer did not submit any client letter, just an address, which was in San Jose, in Santa Clara County, and some vendor details which I didn't know about. Joined the company in June 2017. Huh? How did you do that? Or maybe you were not a quota case. Start date mentioned in LCA was October 2017. Joined my company on June 2017, even before the LCA started. That's odd. You can't really do that. And LCA also have a different intended employment address. Well, I don't know what you can do. This is a very difficult situation to give an opinion on. I think it is very important for the employer. I don't think you have much of a problem. At the most, status can be an issue. You may have to go outside USA for a visa stamping. But it is not something that really is coming at you. Employer could have a big problem if they don't have a good explanation for all this. So if I were you, I would take my employer and go talk with a lawyer, somebody competent and good, and make sure that they've looked at all the facts and given suggestions. If there are good faith reasons for these kind of discrepancies, they can be cured. Star 5 if you have a follow-up question. Okay. This is Wicket L Vijay 786. If I work for the same employer in Canada for 6 months, India 8 months, 14 months outside USA, can I come back on L? Absolutely. L1 visa doesn't require that you work in only one country. I have a client who works from Japan and India, and we are going to get his L1 done probably in July, I think. So, yeah, you can do that, no problem, Vijay. Star 5 if you have a follow-up question. Star 5. Ram has a question, Zoomer123, about accreditations. It's funny, this issue just came up yesterday with somebody else too. And we looked up what USCIS has been saying, and they said that if we have a grace period, first of all, if we have taken away the accreditation and you got your degree after that, it means nothing. You don't get OPT, you don't get any of that. STEM OPT. And the second thing they said was, if you are in a grace period, I think you still don't get STEM extension, but you can get OPT, something like that. So I don't remember exactly all the details, but this information is available, I believe, on SEVIS website. So you can go to ice.gov and look at the SEVIS frequently asked questions on accreditations. Okay. Star 5 if you have a follow-up question. PW75 terminated by employer A on November 17, 2017. I-140 approved. Filed H1 transfer with employer B on Jan 16. Hey guys, I'm not going to have time for new questions. I see some people logging in now. I have to go at 1:30 exactly in 16 minutes. Employer C wants to hire me. What all options I have to join them? So you filed your H-1B transfer in the 60 days. Okay, remember the 60-day grace period is the shorter of the two periods when your I-94 expires or 60 days. So if your I-94 is expiring on the 45th day, your grace period is 45 days, not 60 days. Now employer C wants to hire me. What all options I have to join them? You know, I don't think you can. Can you join them? Are you? Yeah, I think you can, because if I remember, I look at the regulation. This is the way I read the regulation. The regulation says you're not out of status for 60 days. So which means if you filed for an employer B within those 60 days, you can start working with them upon filing. But with employer C, could you have done that? I do not know the answer to this question. That's a little bit more complicated than I have given thought to. I would have to look at the regulation 8 CFR 214.2, subsection small h, and then there's a section, subsection like 6 levels deep, M, small m, Arabic numeral 3, small Roman numeral 3, which is what I was reading this morning. It made certain things clear, but certain things were still obfuscated. I would have my employer's lawyers look at this issue, let them do some research. I don't know the answer off the top of my head. I don't know if you can join employer C right away. Can they do my H1 transfer on premium? Yeah, but that time is gone. The 60 days are gone, right? You can certainly try. Why not? Because there is also that regulation that I mentioned which said if the previous cases are denied, then the others fail. You don't have a denial. You just have a filing and then 60 days expired. So try. Yeah, you can do H1 transfer premium processing. Try it. Can they do consular processing? Yeah, they can. But consular processing I would avoid because it can take so long. They can get you stuck there. And if the employer is giving you trouble by not putting you on their payroll, not paying you, you can file a complaint with the Wage and Hour Division of the U.S. Department of Labor. If you do that, that gives you a good reason not to have pay stubs. *5 if you have a follow-up question on this. Yeah, I would do premium processing if I were you. Let's see. This is Missouri. Missouri, go ahead, please.
Hi, I'm talking about this question only, which you were answering. So, what are my options? Like my employer C really wants to hire me, but they are. So, what are my options? You already answered that, but what is my status now? Can I stay here for how long I can stay here?
Yeah, because as long as your case through employer B is pending, it was timely filed within the 60 days. You can stay here, no question about it.
And my I-94 is for next year. So like how long? Like because
once it is filed, you can stay as long as the case is pending. But you're going to do employer C.
Okay, and what if
ma'am,
denied? Like after some time, case denied. What is my status?
Let me finish my sentence. You're going to do C premium processing anyway, so you should be okay.
No, that is right now we have just did the regular processing, so that is one option I was just thinking of, because I don't know he will be ready or not. So if the things go the same way it is going, and after 2 months or something, if my H1 denied, which I am hopeful it won't, but still then what is my status at that time?
Which H1, B or C?
B.
If B is denied, you would have to leave the USA.
Okay, so I would be like something it was like on my status or something, or I will be just good leaving.
Leave as soon as you can, maybe a day or two or a week.
Okay, and one more question. If this employer C is somehow, so what is the best option if H1's employer C wants to file? Is there any one option which is like, I have to choose between the devil and the C? So what is the best option, the consular processing, or they just need to file and I should start working?
No, don't start working, but file premium processing. Have your lawyers look at whether or not you can start working. I don't know the answer off the top of my head.
Okay.
All right.
Thank you. And it's true because the employer C told the employer of company C told me that if we file, then my case will be like on the back of my employer B case. They won't do anything till the time they decide something about the employer B H-1B.
That's
so is it true?
That's not true. No. At worst, they can deny status and ask you to go outside for visa stamping. They can't hold up the H1 adjudication. No, that's incorrect.
Yeah, that is why my question, you really answered that. So because I just want them to file the H1s for my employer C, and they were just telling me all the time that it is, so anyways, there is no harm filing, right, with H1, with the employer C?
Not even a little bit.
Okay. Okay, and if I was actually telling them for like requesting them for go for consular processing, so is it that my better option or just filing here like a regular H-1B? What is better for me?
Consular processing is an option that exists anyway. So why would I take my worst option when I have a better option? If my better option fails, I have to go to consular processing anyway. Why would I go for consular processing? That's silly.
Yeah, that's what actually I was just like, I was quite in dilemma for so long because of this, because after like I was.
Here is the problem. Immigration law is extremely complex. In our office, I usually don't like our lawyers to talk with anybody and give advice until they have worked with us for at least 10 years. Okay? So you have lawyers who are either inexperienced or haven't read on that particular issue, because there are so many issues in law anyway. So I think it's a good thing that you guys educate yourselves and know what's going on. Filing for consular processing makes no sense to me. Okay?
Okay, and one more thing.
I gotta go, man. You're gonna have to make it really quick. I have a couple of other questions to deal with.
Okay, just last question. By any chance, can I change my status to F1 and that will be okay if I go for like
at this stage you are not in status. You are in authorized period of stay. Listen to last week's last time's recording. I recorded a whole discussion on what is the difference. You will not be able to convert to F1 within USA right now. Okay? Good luck.
Okay. Okay, thank you.
Bye.
Thank you.
You're welcome. Sorry guys, I'm pressed for time. I've got only about 7-8 more minutes left. Okay, I think we just finished this. So B. Sundar, he asked a question on Feb 22nd, not clear. My wife is currently on H4 visa with EAD. Employer has planned to file for H1. Can we go for H4 stamping on April 2nd? You can, but you have a problem. The problem is this. First of all, in H1 there are two processes. One is the H1 approval, the other one is change of status. If you leave or you're outside USA when the H1 is filed, they'll have to ask for consular processing, or you'll come back. If you get selected before October 1st, you'll have to file for change of status, which is like doing H1 all over again. Second question, what will happen to her H4 if the H1 is picked but rejected? Can she continue to be on H4 visa until its expiry? Absolutely. Just because you filed an H1, it was denied, whether you are on F1 OPT or you are on H4, that status is not taken away. Folks, some of you are just joining me. I will not be able to take any more new calls. We are finishing up this in about 6 minutes. I got to go. Sorry about that. Star 5 if you have a follow-up question on this. Star 5. Okay. Rakesh says, I am on H-1B. Employer A terminated my employment in the month of November. Revoked my H-1B. I filed H-1B in December. This is dangerous. No, but you have a 60-day grace period, right? Assuming that your I-94 was valid for some time after your November discharge. Okay, so here is the question. So they filed in December within the 60-day grace period, assuming that this was available. For my H-1B transfer to employer B, I received an RFE which looks tough to be answered. If H-1B transfer gets denied, will that mean I'm out of status from the date of termination with my private? See, that doesn't really matter because you are in authorized period of stay. You're not illegal when you have a case pending. That doesn't matter. And it's legal for you to get paid in that time. If my H-1B transfer gets denied for any reason, what are the options? You'll have to go outside USA to get a visa stamping for another H-1B, which has to get approved. You won't be able to do it from within the United States in your situation. Right. Chances are, Rakesh ji, you'll have to go outside USA for a visa stamping if this case is denied. That's what it looks like to me. Now, if you have another employer who wants to file an H-1B, let them file it right now. Try it out. I doubt very much government is going to be easy about giving you status within the United States if employer B's case is not approved. But no harm in trying. Worst case scenario, you have to go outside for visa stamping. Star 5, if you have a follow-up question on this. S. Babu, I hear, oh, there is a question. From Pennsylvania. I'm not doing new questions, only a follow-up question on what I just discussed. Pennsylvania, go ahead, please.
This is Rakesh. Yeah, my question is that can I be able to file a new H-1B transfer based on the receipt from the previous employer?
You see, the question that you're asking is confused. You know why it is confused? Because the fact that you have a case pending does not give you status. It only gives you the legal right to stay in the US. If the preceding case is denied or pending when your next case is filed or adjudicated, they'll make you go outside USA for visa stamping. Can you file? Yes. Is your conversion within the United States guaranteed? Not at all.
Okay.
Good luck.
Yes, thank you.
You're welcome. Okay. Let's go on to S. Babu. I hear rumors that priority dates could be fast-tracked for 3 years in the 2-3 years in the near future. We don't know. I don't know what is going to happen. No way of knowing. 2, I've been with a consulting company A for the past 7 years. My date is 2012. Moving to another consulting company. Can I work for both A and B with concurrent H-1B? Oh, absolutely. Yes, you can. If I do, and if my priority date becomes current, can I use my I-140 with employer A? What are the risks involved? No, that's it. That is too long a topic. As long as there is a job honestly available and you intend to take it with employer A, you can always use that I-140. In the meantime, if you also want to work on a second job, you can. I had a client who had 3 concurrent jobs. At one point, government questioned me, how can you work 120 hours a week? And I explained to them that he's a senior database administrator. He just has to be on call. So he only goes in when there is an emergency. So you could have as many concurrent jobs as you like. As to precautions and risks involved, too many for me to go over. The most important precondition is it is done in good faith. They have a job open. You want to join them. Later on, things change, that's okay. But on the date the 485 is filed, when the dates become current, that should be the situation. *5 if you have a follow-up question. Okay. This one is from Connecticut as well. Yes, Connecticut, go ahead, please.
Good afternoon, sir. So, if when I say I'm working concurrent, does that mean I have to be getting pay stubs from both employers, or is it okay if I get pay stubs from only one of them?
No, that's not working. That's volunteering. So if you're working, you've got to get pay stubs from both employers. Volunteering is illegal in most cases for private employers. They can't take your work without paying for it.
Okay. So let's say I quit my job with employer A, and if my priority date becomes current, and at that time employer B, say my is in the middle of processing, so can I switch back to employer A?
I have always had a problem with this scenario. Please go over the frequently asked questions in the last I've discussed this issue many times in great detail.
Okay.
So just go to our frequently asked questions. If you still have something residuary, go ahead and post it. We'll talk about it in 2 weeks. Okay?
All right. Thank you, sir.
You're welcome. Good luck, sir. Okay. We did Babu's case. Now we have IMI Assist. USCIS has recently issued a memo about validity period. So the idea is, if I've got 3 sub-vendors and one says the project is for 3 months, another one says 6 months, another one 12 months, well, I think USCIS is going to go with the shortest. I would argue that it is the end client whose contract matters, but I really don't know how you manage these things. I've never had a situation like this, but my first instinct is to get end client as the main source of the project duration. That would be my advice. Everything else can be rearranged around that. *5 if you have a follow-up question. Ravi Ganesh, same question as above. H-1B is currently valid for 6 more months. There are 2 vendors in between. Client extends my contract every 2 months. They are willing to give a letter for long term. You're going to have to talk to your lawyers. Every case is different. I think getting a letter from both the end client and middle vendors saying that is the intended period of contract, we've been doing it for so many years, we intend to keep doing it, I think that would substantially justify a longer duration. So again, these are very fact-bound issues. Difficult for me to make a generic judgment call. Okay. Let's see. I'm pretty much done, guys. I have to leave. Any follow-up question on this issue that I just discussed? *5. Okay. There is one from Kansas. Kansas, go ahead, please. Last question of the day. Kansas?
Ravi?
Ji, Ravi.
Yes, sir. I have this extension on September, so my client is letter to give me a letter.
I understand the facts of your case. I understand the facts of your case. I can't give you an answer because each situation is very specific.
Okay.
So you need to work with your lawyers. I can't give you a generic situation, generic solution. It's not one size fit all.
Okay.
Okay. Sorry.
Okay, so right now if we file for extension, do you think the letter would do, or do we need to actually have the contract? Or that's what the memo says, that the validity period depends upon the contract or work order or statement of work.
I don't remember the exact language, but when I looked at the memo, I did not see any difference in the memo from what they were already doing. So from what I recall, the memo didn't have any changes over the existing practice. It was just basically writing out what they were already doing. And what are they already doing? You have to prove the existence of the contract, the work duration, the project, and that can be done through a letter or a work order or contracts. Whatever proves how much is the duration, what is the job title, how long is the project for, and what is the job description. These items have to be proven, and the employer-employee relationship, who has the right to control. If you can prove that through the end client letter, I think that should be sufficient.
Okay, sir. So if my H1 gets denied, I actually have done my master's here. Can I apply for F1 visa once again?
You could be out of status. That is the only problem. So if you're gonna do a student visa or something, or student status, you might as well do it within the life of your existing H1. You can file for an F1 change of status. Keep in mind there is a rule about 30 days of status, etc. Talk to your school. And once you file the F1, you can also file an H1 extension or do it premium processing. If that comes through, cancel your F1.
Got it, sir.
Okay. Good luck to you.
Thank you.
Oh, you're welcome. Good luck.
Thank you.
All right, folks. Good talking with all of you. I've got to run. In 2 weeks, we'll talk again. I hope I'll have time. I'll let you know. But the next 3-4 weeks tend to be very busy until April 1st week, when we'll have a little bit more time. And then the RFEs start. Good luck, everyone. It's great talking with you. We always like to be of service. Thank you very much. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.